The next is the external, the attribution to circumstance. Circumstance is the external causation. Jurors underestimate the effect of external forces, situations, or circumstances as an influence on causation and damages. How do we use this? How do we turn this around? Because going in, it's anti-plaintiff. So the way you turn it around is this. You have to negate the influence of the personality of the plaintiff. You have to show that this particular plaintiff did not do anything. There's nothing about this plaintiff's personality, traits, and so forth that contributed to this injury or to this tragedy. But remember, there are two personalities involved in the case. There's also the personality of the defendant. So you focus on the influence of the personality of this defendant. You show this defendant's bad choices arising out of this defendant's personality traits. You've got a drunk driver. You show the influences of the personality of the defendant that he personally chose to drink and drive. And he personally chose to do all the things he did. And then you negate the influence of the personality of the plaintiff. So focus on the personality of the defendant as causative, and then the fundamental attribution error, which is placing personality ahead of circumstance, can be turned around to work for the plaintiff if you make it the personality of the defendant with the availability bias that you focus on. So then you stress the influence of circumstances as they bear on the actions of and injuries to the plaintiff. The circumstances were created by the defendant. As often as not, the plaintiffs react to actions by the defendant. So you stress the circumstances as they bear on the actions of and injuries to the plaintiff, with the idea that the circumstances were most generally created by the conduct of the defendant. So you stress the influence of the defendant in creating and controlling the situation and the circumstances, and stress the personality of the defendant and negate the influence of the personality of the plaintiff, and you can make the fundamental attribution error work in favor of the plaintiff. The next attribution error is called the purposive attribution. Purposive attribution is this, that in controlled circumstances, if the plaintiff is in a situation where they are not in control, the defendant is in control, which is generally the circumstance. Purposive attribution says this: if the individual whose conduct they're examining acted on purpose, now that is not to say intentionally or willfully, but just acted on purpose. Go back to the same magic word. They chose. They acted by choice. Then the jury will punish. They will find negligence, and they will punish a person that acted on purpose and caused a tragedy. So it's purposive attribution, control conditions. So you show that the defendant was in control of the conditions, and the plaintiff had no control of the conditions. The classic example of that is a medical negligence case. The doctor's in 100% control of the conditions. In surgery, for example, the plaintiff has zero control. So the doctor chose to do what the doctor chose to do. Now, in a driving situation, you get to the other side. The other attribution is called reactive attribution. The good thing about this is the jury will forgive someone who is in a reactive position. That is to say, they are reacting to circumstances or conditions out of their control. And they are injured, and maybe they don't react as a reasonably prudent person would have reacted. But a jury will forgive if you can emphasize the reactive nature of their conduct. This really works advantageously to the plaintiff because the plaintiff is almost always in a reactive posture. The plaintiff is almost always reacting to the purposive conduct of the defendant. So you can make both purposive attribution and reactive attribution work in favor of the plaintiff if you couch it in those terms. So look at your case and decide from your case, was the conduct that which caused this tragedy created, were the conditions created by the defendant? Was the plaintiff merely reacting? And then you offer hard, firm evidence and then argue it that way. You make that argument to the jury that this is a reactive situation.